Hey, I'm firearms attorney Gilbert Ambler, and today I want to talk to you about a new development in the rare breed trigger, the forced reset trigger drama that has gone on for the past several months. Before we dive into it, as always, if you have not yet hit that subscribe button, go ahead, hit that subscribe button. Make sure you share this content so not only you and your friends can keep getting this pro Second Amendment related content. Now, quick refresher on rare breed triggers. If you're not familiar, rare breed and wide open triggers are forced reset triggers, okay? Forced reset triggers, I think the easiest sort of 1,000-foot overview of these triggers is they operate very similar to the manner that a bump stock operated, only it's all contained within the trigger mechanism. Same idea. The trigger resets very, very rapidly, and the rearward pressure of your finger on the trigger causes the firearm to discharge very rapidly. Now, the ATF, like bump stocks, where ATF took the position that bump stocks were machine guns, and we know that at least in the Fifth Circuit, the ATF was wrong about that, but like the ATF taking the position with bump stocks, they have taken the position that forced reset triggers are unlawful machine guns. Now, Rare Breed did not accept this lying down. In fact, Rare Breed still has their website up there, still selling these things as best as I can tell. So, Rare Breed has been fighting them tooth and nail. They've been fighting them in civil court. They've been fighting for injunctions. Those civil challenges have not necessarily been going well for Rare Breed, and it's probably going to get worse because now the government is going on the offensive against Rare Breed, and they filed a lawsuit in the Eastern District of New York. Now ask yourself, and I'm not going to comment on this other than to ask the question, why would the ATF be filing lawsuits in New York when Rare Breed was based out of Florida and North Dakota, where the rest of the litigation is? So, interesting there. I wonder why they would pick New York. Anyway, as part of this lawsuit, they have alleged that Rare Breed has engaged in mail fraud and wire fraud and conspiracy to defraud the U.S. government. So these are very, very serious allegations. And as part of these allegations, they are requesting that the court order Rare Breed to preserve all of the records of their shipping and their transfer and their sale and their manufacturing. All of those records they want preserved. Why would the ATF want all of those records? Well, I think we already know the answer to that. They want to be able to track down the people that purchased these Rare Breed triggers because their claim is that those Rare Breed triggers or those wide open forced reset triggers are already machine guns, okay, irrespective of whether you have installed them. Now, I know people have seen this coming, so people have been worried about this. I know my law office took a lot of calls about this back when this first started, and I want to point out to anybody who might still be in possession of one of these things, absolutely do not comment. Do not post a comment identifying yourself. That would be a very, very bad idea because the ATF is looking for things like that. But this presents a little bit of an interesting opportunity because if the ATF has not yet contacted you individually, because they maybe have not yet gotten your shipping records, and I understand from talking with folks that Rare Breed went out of their way to try to make sure that they destroyed records like that, so whether they will be successful in that, we don't know. But if it is possible that the ATF will get your shipping records, but they have not yet done so, meaning they have not yet identified you as a person possessing one of these triggers, it presents a very rare opportunity. Because once the ATF notifies you that they think you are in possession of one of these things and they're investigating you, then it would become the crime of destruction of evidence if you were to destroy or get rid of the trigger. But up until you have that contact directly from ATF saying, hey, you're the subject of an investigation, it's a rare opportunity because you can actually get rid of the trigger right now. And I know no one wants to destroy a $400 or $500 trigger, but you can get rid of that trigger and it doesn't count as destruction of evidence. And then you can simply invoke your Fifth Amendment, keep your mouth shut if the ATF ever contacts you, and the burden would be on the ATF to prove your possession. Again, criminal statute, they're going to have to prove your possession beyond a reasonable doubt, and that would be very, very hard to do if they can't find you in actual possession of the item, okay? Now, some people have talked about, hey, if I destroy this thing, should I take a picture of it in the destroyed format and get that picture over to counsel? that is something you could consider doing. I would tell you not to videotape the destruction, because videotaping will start out with the object in its original format, and I don't want the ATF to be able to have a single image of the object in its original functional format. Okay, so if you take a picture after you've destroyed it, some identifying information of yourself in it, and make sure that that picture goes to counsel, because again, it's supposed to be prepared for counsel. That way you have attorney-client privilege, so you wouldn't talk to an attorney if you're thinking about going down this route. As always, if you're interested in this content, hit that subscribe button, share, make sure that your friends find out about us. Until next time.